Droit maritime et les conventions internationales. C'est le thème de ce premier panel que nous allons bien sûr débuter avec vous. Monsieur Norman Martinez, please, you may come. Directeur général de l'Institut de droit maritime international. Il sera question avec vous de la limitation des responsabilités dans le droit maritime. Je vous en prie. Évidemment, nous allons prendre une ou deux questions à la fin de chaque intervention, des questions ciblées. Veuillez vous présenter avant chaque intervention, si vous le voulez bien, si vous n'y voyez pas d'inconvénient. Merci beaucoup. Please.
Good morning, everyone. Once again, it is an honor to be here. I am standing before you to try to summarize in 15 minutes something that would take hours and hours to discuss. But it is, in my professional and practical experience, one of the most important topics that you would handle in the case of a big crisis, because before any liability is established, we don't know what happened, but as soon as you threaten, let's say, the ship owner or the person possibly responsible with the arrest of a ship, etc., the first topic that would come to the fore is that of limitation of liability for maritime claims. Limitation of liability for maritime claims is a topic of respectable antiquity, but I just chose the picture of the Ever Given to give you a perfect example that is something that we are experiencing even today. To start, what is limitation of liability? Limitation of liability is the rule that allows those who are parties to the marine adventure to cap their maximum financial exposure up to a certain limit, regardless of the amount of claims that are brought before them. But for this particular session, I'm speaking of global limitation of liability. And we have to distinguish global limitation of liability from what I have come to name as particular liability regimes. Particular liability regimes refer to claim-specific conventions that usually deal with issues of liability and in many cases include provisions on limitation of liability. We have areas such as carriage of goods by sea, like the Hague-Visby rules, Hamburg rules, Rotterdam rules. Algeria is a party to the Hague rules, which curiously this year is celebrating its 100th anniversary. A carriage of passengers and their luggage by sea, which we have the Athens Convention 74 and the Protocol of 2002, in which Algeria is not a state party, and we'll mention that later. Pollution conventions like the civil liability for oil pollution damage, Algeria is a party to the 1992 CLC. The Bunkers Convention, which Algeria is not a party, or the HNS Convention, which Algeria is not a party, but it still hasn't entered into force. And we also have the Convention on the Removal of Wrecks, which Algeria is not a state party. But these conventions provide for liability and for claim-specific areas. We are dealing with the maximum exposure, the global limitation of liability. To give you an example of this, if you have a ship loaded with many containers, but in one such container you have a car, and that car, as we see, gets damaged, and another container gets thrown overboard, we're not dealing here with global limitation. We're dealing with specific limitation, which would be calculated per package or per unit, in this case under the Hague rules, which are applicable in Algeria. Insofar as global limitation of liability, we have 100 years of international regulation. The first convention was adopted on the same day as the Hague Rules, which is the 1924 Limitation of Liability Convention, didn't get much acceptance in the international community, so the international community adopted a second conference in 1957. That came a bit of a longer way, and it gained more acceptance. And then, with the decrease in purchasing power, the construction of bigger ships, it was found necessary to adopt a new treaty. And this was the 1976 Convention on Limitation of Liabilities, which we refer to as the LLMC Convention. And Algeria is a state party to the 1976 LLMC Convention. But the question is this enough? because we have stayed a bit behind in international regulation. After that convention, to which Algeria is a state party, a protocol was adopted in 1996, which increased dramatically, almost 4 times as much, the limits of liability, and it also provided a new system of tacit acceptance to keep on increasing the limits of liability without the need of calling a new conference. And based on this tacit acceptance procedure, the IMO Legal Committee adopted in 2012 Resolution 599, which increased the limits of liability of the 1996 protocol. And these new limits of liability entered into force in 2015. That is the current international regime on limitation of liability. But something very important, and you will see the importance of what I'm about to say when we finalize with the practical examples. The 1976 Convention and the 1996 Protocol, although the protocol is to amend the Convention, under the Vienna Convention on the Law of Treaties, are 2 separate and distinct international treaties. In other words, Algeria only has international relations with the state parties to the 1976 Convention, but has no relations whatsoever with the states that are parties to the 1996 Protocol. And the effect of this is very important, and we will mention it later on. Let's just see just a few things of limitation of liability of the LLMC 1996. As you see from the 4 pictures I have chosen, we're not talking about a small damage in which usually the particular liability regime will apply. We're talking here of catastrophes that will have dramatic financial implications. The first point that I want to mention is that the LLMC Convention is not a liability convention. It doesn't tell you who is liable or what are the bases of liability. That you will find it under contract, under the general law of torts or negligence, etc. It just deals with limitation of liability. So it just tells you who can limit liability, for which claims this person can limit liability, what is the conduct that prevents limitation, the limits of liability, and procedural issues. So it doesn't deal at all with who is liable. It is just limitation of liability. Among the persons that are entitled to limit liability is no longer just the ship owner. The ship owner, in fact, comprises the actual owner, the manager, the charterer, or the manager or operator of a seagoing ship. It also includes salvors, and also it includes any act of a person for whose act, neglect, or default the shipowner or salvor is responsible. This may go beyond the crew. And also the insurers of liability, to the same extent of the assured himself. And you will see in reality that when we deal with these catastrophes, we're dealing usually actions between insurers. Now, when we deal with what is it intended to cover, Article 2 of the Convention lists the claims that are subject to limitation of liability, and Article 3 lists the claims that are accepted from limitation. I'm not going to go into all of them because we don't have time, but it is important to note that the Convention allows state parties to exclude the application of Articles 2, 1D, and E. This is the reservation of the 1996 Protocol, but the first reservation is also included in the 1976 Convention and was a possibility for Algeria to make. Now, this relates to wreck and cargo removal. So, Article 18 of the Convention allows states to make a reservation in relation to wreck and cargo removal. Now, curiously, Algeria did not make this reservation, but Dunya has just handed me a copy of the Maritime Code, so I was trying to browse through it, and it seems that Algeria, although not having made a reservation, has included wreck removal as one of the claims accepted from limitation. This is very important because there is a conflict now between the obligations at an international level and national law. But why is this important to have? Imagine the removal of the Costa Concordia. The Costa Concordia was 114,500 tons. And the vessel's limit of liability for these cases was around 61 million euro. But if you do not make a reservation, that's what you would get, 61 million. But the actual removal of the Costa Concordia costed around 1.5 billion euro. So who will pay the difference? So although Algeria didn't make it at an international level, it is very important what has been done in relation to national law, but it would be important that if you become a party to the 1996 protocol, that reservation is made. Now, in the idea of this, and this is one of the things that I just realized in my very limited French, so I may be mistaken and I stand to be corrected, is that the idea of the 1976 convention is that basically the ship owner should be entitled to limit liability in all cases. When the conference adopted the formula, it was deemed to be virtually unbreakable. And before, the concept was fault or privity. But Article 4 says that a person liable will not be entitled to limit liability if it is proved that the loss resulted from his personal act or omission committed with intent to cause such loss or reckless and with knowledge that such loss would probably result. However, in Article 92 of the Maritime Code, I will not intend to translate, to speak in French, but I understand that it says, if a fault is proven, is a personal fault is proven against the person. So, although we're a party to the 1976 convention, it seems that we're using a test that was before the 76 convention, and that can create a conflict at an international level. Algeria will not be the only one that is where this is happening, and many countries were actually allowing the breaking of the limitation of liability, so much that on 15 December 2021, the state parties to the conventions, to the LLMC 76, to the LLMC 96, and the CLC 92, adopted at IMO a unified interpretation, a resolution on a unified interpretation on Article 4 to prevent states from easily breaking the right to limit liability. And the idea, I'm just going to mention one sentence of this, is that limitation of liability should be virtually unbreakable in nature, breakable only in very limited circumstances and based on the principle of unbreakability. So it is hoped that with this, the ship owner will always have a right to limit liability unless it is an extraordinary circumstance. And we will mention why this is important. Insofar as the limits of liability are concerned, Article 6 provides two limits of liability. One is for claims for loss of life and personal injury, and one for any other claims. And they are calculated using a sliding scale in which the bigger ships pay less per ton from any other ship. Again, we will not be able to discuss how this works, but I will give you one example. This is the rules of the convention. Loss of life or personal injury, just to get an idea how it changes, for the first 500 tons, the limit is 333,000. That is the applicable law in Algeria, by the way. And then afterwards, it starts going from limit to limit in tonnage, which each slice, if you see here, is 500 units, and then 333, and then 250. The bigger the ship, the less it pays per ton. And the limits for any other claims are even less, which are almost half as much. Now, with the 1996 protocol and the resolution of 2012, the limits went almost 4 times as much. So instead of 333,000, now we have 3.02 million, and so on and so forth. The limits were much higher, and the effect of this, we will see it very shortly. So I just wanted to put this so that you can see the limits of liability that apply in Algeria are, in fact, done by reference to the convention, but the protocol limits are much higher and would protect much more the victims of a big accident. Even insofar as passengers are concerned, the limits under the 1976 convention are 46,666 special drawing rights multiplied by the number of passengers the ship is certified to carry, but a maximum of 25 million. a maximum of 25 million. And just to give you an idea, this is the Viking Saturn. I did a quick search, and it is scheduled to call in Algeria on 25th November 2024. It has a capacity of 928 passengers. So imagine if ships like this, if there, God forbid, would be a catastrophe, that means that each passenger would receive a maximum of 26,939. We're talking of around probably 28,000, 30,000 euro, which is a very, very small amount. Whereas the 1996 protocol, from 46,666, it went to 175,000 multiplied by the number of passengers the ship is certified to carry, and removed the cap of 25 million. So this is something that is very important to consider as well. So just to round up a bit, how does this come into effect? And we have here the case of the Dali, which is very recent, as you see. But let's step back a bit to the Ever Given. On 23rd March 2021, the Ever Given, as you know, ran aground the Suez Canal, blocking the canal for around 6 days. It not only did it suffer damage, but it caused a lot of financial losses because of the ships that were delayed. And it faced claims of around 916 million, including 300 million in loss of reputation. So imagine, for argument's sake, that would happen in Algeria, because this is what I'm trying to put. The calculation of the limit under the 1976 convention was around 32 million US dollars. But under the 1996 protocol was around $116 million. Now, Egypt, like Algeria, is a party to the 1976 convention, and an Egyptian court arrested the ship. So technically, the ship owner could have gotten scot-free by depositing the 32 million and getting his ship released. But since Egypt is a party to the 76 convention, like Algeria, but not to the 1996 protocol, and there are two separate treaties, a claimant could have sued the ship owner in a 1996 convention country. And therefore, on 1st April 2021, a limitation claim was issued in the Admiralty Court in the UK, seeking a general decree of limitation. And the UK is a party to the 1996 protocol. So therefore, the fund that was established, even if the ship was arrested in a, let's call it 32 million country, the fund that was established was in around 116 million. And the reason for this is because if a state, if a court in Algeria arrests the ships and releases, and the fund is constituted, it doesn't prevent a 96 country from ignoring that fund and demanding the higher fund. So to be safe, to have the mines at risk, Algeria may consider moving to the 1996 protocol. We also have the bridge, of the Baltimore Bridge collapse. This was in March 2026. You know that there were people that actually lost their lives, but that fell, there was loss of cargo, and the Dali flies the flag of Singapore and had a tonnage, it was a smaller tonnage, of 95,128 tons. Now, calculating this is perhaps oversimplifying the issue, but calculating the limit under the 1996 protocol, the limit of liability was 132 million. But the test, as I mentioned before, to break the right to limit, should be virtually unbreakable. In other words, there is a high limit, but the ship owner knows that that's the maximum he will pay, whereas the claims would be north of 1 billion. But if they would have claimed, as they tried in the case of the US, the US is regulated by the 1851 Act, which is regulated in 46 US Code, in which it is limited to the interest in the ship, which would be around $42.5 million. So the limit is much less, but the test to break the right to limit is just privity or fault. So it would be much easier to break. So I'm just trying to use these examples so that you can see if something were to happen in Algeria, we run the risk of the test to break the limit, and that we have low limits to compensate the victims, and the fact that our limits would actually be ignored if moving away. So having said this, what is the overall effect of limitation of liability? The right of limitation of liability provides ship owners with certainty, legal certainty, about their maximum potential financial exposure, and there allows the respective insurers to maintain the cost of reasonable premiums, which in turn allows all of those who are involved in the maritime industry the possibility of maintaining competitive prices and therefore benefiting the ultimate consumer. So, in conclusion, it is reasonable to argue that limitation of liability is essential to the maritime industry. When the 1996 protocol was being considered for upgrade for the 2012 resolution, the government of Australia had proposed basically a polluter pays principle, unlimited liability. There have been instances in which the concept has come under challenge. But if notwithstanding the view that it is essential to the maritime industry, one would like to demonize the concept, we have to consider it as a necessary evil. Because it's true that it was created to protect the ship owners, but now I believe it protects society as a whole. Because if you have this, you have ensured prices in everyday affairs. Okay, so I hope that this gives a very brief explanation, but I'm open to any questions that you may have.
Thank you very much. Nous allons prendre une question, si vous le voulez bien. Une question. Allez-y, mademoiselle. Je ne sais pas s'il y a d'autres qui souhaitent poser. Nous allons voir si d'autres personnes qui n'ont pas posé de questions. Non? Allez-y, allez-y.
Good morning, Monsieur Martinez.
Synthétisez votre question, s'il vous plaît.
Oui.
D'accord.
Thank you for being here and sharing with us your valuable knowledge and experience. I'm a P&I correspondent. I'm very much interested by the topic today. My question, and I will ask it in a brief way, what is your advice to Algeria in order to be able to benefit from any conventions in the shipping industry, especially that we have been facing big maritime claims recently, alitions, grounding, and everything. And do you think that Algeria should ratify the soonest the protocol of 1996, and if such protocol would preserve the interests of all the victims, as you mentioned, or the civil parties, ports, or anybody who suffered from the incident? Thank you very much. Merci.
Oh, you have put me in the hot seat here.
Maybe, please, short answer.
Yeah, sure.
Thank you.
This is a very personal opinion. I have just finished drafting the law on limitation of liability for the government of Honduras, which was basically on the same spot. And I believe that by becoming a party to the 1996 protocol, you avoid the uncertainty of a possible conflict with a state that is a party to a 96 protocol. You increase the benefits that can be allowed to victims, so you protect the victims. Insurers will be covered, ship owners will be covered by their respective insurers, and as such, you are ensuring that a competitive prices. So I do believe that it would be important to become a party to the 96 protocol.
Shukran. Merci beaucoup. Thank you very much. Merci beaucoup.